Okay, good morning. Welcome to an oral argument session of the 5th District Court of Appeal. I'm Judge Eisnagel. I'm joined on the panel today by Judge Harris and Judge McIver. Please go ahead and make sure you've turned off your devices or silenced them, as even though we're on Zoom, those could be disruptive. Let's see, for the appellant, you can certainly have a rebuttal. If you'll let me know how much time you'd like, I'll attempt to help you watch the clock.
Okay,
How much time?
5 minutes, please, Your Honor.
5 minutes. Now, it is your responsibility. If I miss it, you got to catch it, but I'll attempt to help you there. So 5 minutes in rebuttal. And so I'll try to help you watch the clock. And with that, counsel for the, let me say, this is case 22-2393, Progressive versus Express Care at 11 o'clock, correct?
Correct, Your Honor.
All right, very good. Okay, with that, the counsel for the appellant is recognized.
Thank you, Your Honor, and may it please the court. I'm Ken Hazuri, and I am counsel for Progressive, the appellant in this case. And what we're here on today is what's known as a billed amount dispute. And it relates to how much should be paid for medical services under our PIP statute here in Florida.
Mr. Hazuri, is there anything materially different in this case than in the case that you guys, that was argued by Mr. Barr in front of the Supreme Court back in March? Is it the same issue?
It's the exact same issue, Your Honor. And by way of information, I know there's a different motions panel. We moved to stay this appeal pending that decision. It was denied. So here we are, we briefed, and we're here at oral argument. But that's cutting right to the chase. We submit that would be the best way to resolve this appeal, is simply to wait and see what the Supreme Court does in the Revival versus Allstate, Allstate versus Revival, actually, I believe, matter, because it is the exact billed amount dispute that we're here on today. And they're going to resolve this once and for all. And the oral argument was held back in March. I think the expectations are that a decision will be made this fall, could come out anytime at this point. And we continue
Counsel, on a sort of related note, I guess, we have several prior decisions theoretically binding, right? If they're on point and if they haven't been overruled. Why don't you talk about those, and are we bound by them still? Have they been overruled? What do we do with those?
Yes, Your Honor, and that's really where the rubber meets the road. I think in the spiel, if we don't wait for Revival, that's where the rubber would meet.
That and perhaps the statutory language, right, counsel?
Sure, but Revival and MRI Associates and Hands-On and Affinity, not so much, but Hands-On certainly deal with the statutory language.
So tell us, are we bound, and if not, how? And
I don't think you're bound, Your Honor. We've cited the cases in our opinions, in our briefing. Wood versus Frazier, which talks about if the same question is involved, and a later case from a higher authority, in this case, the Florida Supreme Court, can't be reconciled, that you can deviate from stare decisis. Certainly, there's a presumption in favor of that, but it's not unwavering, as stated in Robertson v. State from the Supreme Court. Says the doctrine is said to bend where there has been a significant change in circumstances since the adoption of the legal rule, or where there's been an error in legal analysis. So we think you have leeway under those authorities to deviate. Now, another possible solution, I'm going to answer your question too, Your Honor, but I do want to take a quick detour. We to answer part of your question, again, we think waiting on Revival is the best answer, but another possible solution is, if you are concerned about deviating from Affinity and Hands-On, the court's prior decisions, this panel can always ask the entire court to take up the issue en banc and consider it that way.
So
certainly you would be authorized at that point on a rehearing en banc to do what the court thought was best and proper.
Forgive me on the dates. I'm just perhaps mixing up the dates of the cases. Didn't we affirm our prior holdings after MRI Associate?
Good question, Your Honor. The Affinity decision did come after MRI Associates. The Hands-On decision was prior to MRI Associates. So in fairness and in full disclosure, the affinity decision does, restate, what is essentially the holding of hands-on. I would like to point out, and I'm going to get back to your original question about the interpretation, that there is a little bit of an unusual, and I'd say this saying you can take judicial notice of your own court's records and what have you as an appellate court. So do want to touch on affinity. And some of this is stated in the affinity opinion actually too. There was an unusual situation there. That was one where the opinion or the appeal was fully briefed before the county court, before it got moved up to this court, after the legislation changed and the authority changed. And then the primary issue in that appeal was the deductible issue, the proper application of the deductible, and the appeal was stayed. The affinity appeal was stayed pending the deductible decision from the Florida Supreme Court. And so what happened was the deductible decision came out against, the insurance industry. And on February 9th, 2022, the affinity court lifted the stay. And then that day and the next day, both parties filed notices of supplemental authority with Hands-On and Moransky and MRI Associates and a whole ton of county and circuit court decisions in there. And then the court dispensed with oral argument on March 15th and then issued its decision on March 25th. And they stated in the affinity decision, when I said that some of this was addressed in the decision, they stated that while the case was stayed on appeal, subsequent decisions decided the billed amount issue and the deductible issue.
Mr. Zuri,
So our view is that affinity
Mr. Zuri-
really didn't take a good look at it. I'm sorry. Yes.
so looking at both affinity and hands-on, I'm seeing the language that says there is nothing in the applicable statute or the policy that allows it to pay 80% of the billed amount. Could you just read for me 627-736-1A?
Yes, it's I can pull it up and read it, or I can tell you the key part of it is it says 80% of all reasonable medical expenses.
Okay.
And there is the authority to pay 80% of a billed amount right there, as was found in the Back on Track case from the second DCA, and as is or at least inferred from the MRI Associates decision. 80% of all reasonable expenses is the coverage mandate under PIP. It is the heart of the PIP statute as set forth in virtual imaging, orthopedic specialist, and MRI Associates. When the provider submits a charge, it is making a representation that that is a reasonable charge for the services, because under 5A of the PIP statute.
So tell me, how do we resolve the plain language of that statute then with the holding in hands-on and with affinity?
Respectfully, we would submit that hands-on and affinity were wrongfully decided, incorrectly decided, I should say, and they should be receded from based on MRI Associates and what we believe will be the holding of revival.
Well, counsel, you may or may not be right about that. But I think in fairness, when I read those opinions, I think that our court latched on to language in a different part of the statute, right? Which if you only look at that particular phrase, it sort of does sound like hands-on is correct. Would you agree?
I would agree with you. That's exactly what the court did.
Of course, what we know now is, well, hopefully we know is that statutory interpretation does not just look at one phrase in a statute, right?
That is correct, Your Honor. And
so I guess my question is, maybe, and I don't think this is the case here, but what if your policy said we'll pay the 80% of the statute of the maximum period? That's what we'll pay. Which is not, I don't think that's what your policy says here, but in that circumstance, would you agree that seems to indicate you've agreed to pay more than the statute would require, right? And would you be bound by that?
Hypothetically, if we had a policy that said we'll pay all medical expenses at 80% of the fee schedule, then yeah, I think we'd be bound. I think we would.
Because essentially at that point you've agreed. Essentially at that point you've agreed to reimburse more than the minimum, right?
Yes, we've agreed to a specific and exclusive payment methodology contractually. So I think under that hypothetical scenario, I think there's a good argument that we would be bound by the fee schedule in that case.
But your
that's
argument
certainly
is
not the case here.
Your argument is essentially that that when we look at the statutory language and as interpreted by MRI Associates, but I'm not even sure we have to look at MRI Associates. We can just, we ought to be able to just look at the statutory language. The argument is, look, that is a maximum, that's a ceiling. That's a maximum amount. The statute says that's a maximum amount. That's a ceiling. And the mere fact that our policy, the statute also requires you to say in the policy, if you're going to adopt that ceiling, right? Which you did in your policy. And your argument is, look, a ceiling is not exclusive. That's just essentially telling everybody, hey, this is the most we're going to pay. Is that that's your argument, right?
That's absolutely correct, Your Honor. And I would add to that a little bit. The notice provision in 5A5 that allows an insurer to do that, which is what MRI Associates, seized on and was put into the PIP statute in 2012, says that you're telling people you may apply the schedule of maximum charges to limit payment. It's may is the language that's used. And the Supreme Court said you can't find that that's an exclusive payment methodology when the language in 5A5 says you may. You may make that payment. It's not exclusive. And then you couple that with the Section 1A is the heart of the PIP statute, and you pay 80% of all reasonable medical expenses. That's the mandate. That's the overriding, mandate that's to PIP insurers. And then when you're talking about, I wanted to add, when you said you look at the entire statute, that's true. And I think Garner and Scalia in their whole text canon they talk about says not only do you look at the entire statute, but you look at the structure of the statute and which ones are the really, really foundational provisions and where are they located. 1A is right at the outset of the PIP statute. It has been interpreted as the heart of the PIP statute. It sets forth the overriding coverage mandate, and it says 80% of all medical expenses.
So I guess the biggest question, or maybe arguably the biggest question here, is then what does that phrase that this court, I think understandably, latched on to in our prior cases. Now that understandably doesn't necessarily mean we were correct, right? But understandably latched on to anyway. The insurer may pay the amount of this charge submitted.
Yes, Your Honor.
Why was our interpretation of that language? What does that language mean? It has to mean something, right?
Yes.
And what does that language mean if not what we said in hands-on in other cases?
Yes, Your Honor. And let me say, let me just say this. Starting out with, as an overriding issue under the whole text canon and everything we're talking about, we would submit that this one sentence in a subparagraph of the PIP statute, 5 subsections in, is not the tail wagging the dog. It doesn't change the overall coverage mandate. And again, when you look at it, the whole text canon, so you start from that starting point, and you've got MRI Associates saying that the schedule of maximum charges is not an exclusive payment methodology, even when it's elected or after.
Let's just stick with the
So I'm going to
stick with the language of the statute. Right?
Sure. I wanted to lay that foundation. So you have to look at it in those contexts, right? So we would submit to you, there's 2 possible interpretations here, and they're set forth on pages 15 through 18 of our brief, 16 through 18. And the first is, personally, this is the one I think is correct. Okay. And that is the purpose of this sentence in 5A5 is to establish is to cover the situation that we are here on today. The provider submits a charge less than the schedule of maximum charges, but to tell insurers that when you do that, you can pay like you would pay any other charge at 80% a reasonable amount. You can accept the amount of the charge submitted and you can pay it at 80%. In other words, you don't have to reprice it to the schedule of maximum charges. You don't have to price it up to the schedule of maximum charges. Now,
well, counsel,
the legislature worded this a little more clearly to say that. Yes, I will readily.
Well, hold on. So I'm following you so far, but it clearly indicates that you don't have to pay the schedule of maximum charges. I think that is beyond dispute. Then the question becomes, do you pay the full amount of that charge? The charge that as it is submitted, right? I know that the statute doesn't say as submitted, but do you pay the full amount of the charge, or do you pay 80% of the charge? That's the question.
Correct.
Using the language of the statute, the entirety of the statute, what's your argument? I understand what you're saying it means, but tell me If we were to write an opinion, how would we justify that?
I think you would justify it by, as we've done in our brief, by matching it up to other language in the statute, including language under 5A5 that just talks about the paying the charge submitted. I'm sorry, 5A1. I'm trying to pull it up for you real quick, but there's language in 5A1 that talks about the insurer paying the charge submitted. And there's no language in there saying paying 80% of the charge submitted, because again, the foundation of this was for years reasonable or fact-dependent methodology. You calculate that and you pay 80%. And so when you look at 5A1, it says, however,
Counsel, for what it's worth, you're almost to your rebuttal time, and I'm following you.
I do, and I'll clean this up on road. But my point is, you homogenize, or you read them all together. If you look at 5A1, there's language talking about the provider or the insurer paying the charge. Okay, it's the mandate is 80%, and you read all of this together. I know I'm into my rebuttal, but I want to finish this point. You read it together. And this one sentence was not intended to be a deviation from the overall mandate. When you look at 1A, 80% of all charges, you look at the language in 5A that talks about just paying a charge without saying paying 80% of the charge. And you don't just create a whole new payment structure, based on one sentence in a subparagraph. And when you look at the overall scheme in the PIP statute, that's the way it's supposed to work at 80%. And I will, I'll save the rest of my time for rebuttal. Thank you.
Thank you, counsel. Okay, and now we have, 4 minutes and 19 seconds left for rebuttal, counsel. And now we have 20 minutes on the clock, and counsel for the appellee, you are recognized.
Good morning, may it please the court. My name is Chad Barr, and I have the privilege of representing the appellee in this matter. Your honors, this case has been a part of my practice for the better part of 7 years. I was involved with this issue even leading up to the Irizarry opinion, and obviously I argued the case at the Supreme Court. And like Mr. Irizarry said, we're waiting on an opinion. Our opinion is quite simply that this court has correctly, along with the 4th DCA, has correctly interpreted not only the PIP statute but also the insurer's actions. I think an important thing that's missing from Mr. Irizarry's argument completely is what did Progressive do, and what do they have to do because of what they did? So, kind of a convoluted question, but the record's 100% clear what they chose to do in this case. They chose to limit reimbursement to the fee schedule, and we know that because we look at their explanation of benefits, and it tells the provider these are the rules based on what we chose to pay. Under 627, 736, 5A2, and 5, you cannot balance bill the patient. So we know right away that they chose, and that's in the record at 130 and 131, they chose to rely on the fee schedule. So we have a discussion has to happen about the language of the statute, but we submit that this court and the 4th have already correctly interpreted the statute. Then we have to look at what Progressive did. And what are the rules? MRI Associates is very clear. It tells us in MRI Associates, if you're going to pay pursuant to the fee schedule, these are the rules. It says that verbatim in MRI Associates. The court didn't get into what does the insurer have to do if they agree to pay pursuant to the fee schedule, or if they choose to pay pursuant to the fee schedule, what their actions require them to do, because that wasn't the issue in that case. The issue in that case was what kind of notice is required and what can they do once they give the notice. So we weren't dealing with charges in MRI Associates that were less than the fee schedule. We were dealing with charges that were greater than the fee schedule. So MRI Associates tells this court they were correct in all the prior decisions when it interpreted the PIP statute as, especially 5A5, as saying, if you elect to pay pursuant to the fee schedule, those are your actions, not what necessarily is on paper, but those are your actions, then you have to play pursuant to the rules that are found in 5A2 through 5. And Judge Eisenhower, you're asking Mr. Irizarry quite directly, what does that mean? Well, it's very simple. 5A1, the fee schedule, was designed to be a limitation. MRI Associates told us it's designed to be a limitation on reimbursement. Okay, so 5A1, the fee schedules, satisfies the reasonable expense mandate, which includes everything in 5A1 through 5A5. So all of that satisfies the reasonable expense mandate. So if a provider is submitting charges that are greater than the fee schedule and Progressive chooses to pay pursuant to the fee schedule, then 80% of the fee schedule satisfies the reasonableness expense mandate. Right? That's what the Supreme Court has told us. But what happens when a provider submits a charge that's less than the fee schedule? Mr. Hazuri seemed to agree with the fact that the provider, the purpose of 5A5, that sentence that this court was concerned about, was so that a provider, an insurance company would not have to pay a provider more than what they billed. They wouldn't have to pay up to the fee schedule. So what are we left with? It's an alternative to something, like the court mentioned, it's an alternative to something. It's an alternative to Progressive, in this case, paying 200% of Medicare when that's not what the provider charged. They charge less. So the legislature knew that some providers would submit charges that were so low that the insurance company would have to pay them up to 200% of Medicare if they didn't include this language, which says you don't have to pay them up to 80% of 200% of Medicare. You can pay it in the amount of the charge submitted. And there's no 80% there. There's nothing there. It says in the amount of the charge submitted.
So, counsel, why don't you respond to your opposing counsel's argument that, hey, look, amount of the charge submitted might mean something different than what we would think it means if we only look at that phrase in isolation. I imagine you agree that we shouldn't look at it only in isolation. So respond to opposing counsel's argument that, hey, look, if we look at the entire statute, how that language is used in other parts of the statute, the structure of the statute, that the amount of the charge submitted is referring to 80% of the reasonable charge.
Well, that argument is premised on, and they said it in their brief, something like it's a floating 80%, like the 80% applies to everything. There's a broader and then a more precise reason why that doesn't really work. If you look at the statute tells us in various places what the insurance company is required to pay. So you've got under 5A1, 80% of the schedule of maximum charges. So if the 80% found in A1 applied also to 5A1, now they're paying 80% of 80% of 200% of Medicare. That doesn't make sense. It doesn't work. That's not what the legislature said.
I'm sorry, counsel, I'm not following you there. Are you talking about 80% of the reasonable charge versus 80% of the schedule?
But what their argument is, and if you go back and read their brief, it's very clearly there. They say that 80% in 5A1 applies to everything payable under the PIP statute. So what we have to do is we have to go then through the PIP statute line by line and say, all right, well, what does it say is payable? So we go to, for instance, 5A1, which is the fee schedule, and that says the insurer may limit reimbursement to 80% of the following schedule of maximum charges. If the 80% reasonableness expense mandate found in 5A1, excuse me, in A1, the beginning, the what they call is the overarching reasonableness mandate. If that 80% applied to everything, then we would have to apply it also to what is already written later in the statute, which is.
Well, let's assume for a moment that this panel is not going to buy that argument, that we've read the statute and that 80% of 80%. Assume for the moment that that's not how we read the statute, okay? But the other argument, the argument I was getting at is, hey, look, what about the council's position that the schedule is a ceiling and only a ceiling, okay? And that, hey, the statute makes very clear at the beginning that the default is 80% of the reasonable charge, right? And no?
That's not the default.
Okay. Well, convince me.
Okay. So the statute says 80% of reasonable expenses. When they say we're going to pay pursuant to the schedule, then we go to 5A1.
No, I know, counsel, that's begging the question. That is the question we're trying to decide on in this appeal, is it not?
That's what the statute says. I don't
Right.
think.
No, I know. The statute said the question becomes, is the schedule, is that a ceiling or an alternative payment method, right? Is it two mutual exclusive payment methods, right? Or is one of them a ceiling and the other one the default? Right? Is that the question?
The 5A1 satisfies the reasonableness expense mandate. So the Supreme Court says they are
You
different.
can.
Isn't your bill presumed to meet the reasonable expense mandate unless it's challenged?
No,
The subsection, or I'm sorry, but subsection 5's introductory language says that you may charge the insurer and the insured party only a reasonable amount pursuant to this section. So when you submit a bill, ostensibly you're following the law doing that. And if Progressive doesn't challenge that reasonableness, then why don't we fall under 1A where they pay you 80% of that reasonable amount?
well, because first of all, we have to look at what they did. We have to look at what they did, and their EOBs tell us what they did, which is they adjusted this claim pursuant to the schedule of maximum charges. So if you're going to adjust a claim pursuant to the schedule of maximum charges, then we look at what is listed in 5A1 through 5. And 5A1 says you got to pay pursuant to the fee schedule, 80% of 200% of the schedule.
Okay, I see,
5A5.
counsel. So you agree. So that you're saying that the only reason that we have this billed amount dispute in this case is because Progressive used because of Progressive's explanation of benefits. Had they not said, hey, we're using the schedule in the explanation of benefits, you would agree that then the reasonable 80% of the reasonable amount would apply under the statute.
No, I don't, because their policy tells us that
Well, let's-
they are.
Then let's stop talking about the explanation of benefits for a minute and let's talk about the statute. So let's not refer to the explanation of benefits because I think that's confusing it. At least for me, it is. Let's talk about what the statute requires, regardless of the EOB.
And your question really goes to, I believe, if I'm trying to get back to it, and I apologize if I've kind of gotten off track with answering it, but what we have here is a situation where the statute has two different, the Supreme Court said they're not mutually exclusive, but they are two different methods for determining reimbursement. The Supreme Court said that. So in this case, we have a situation where their policy says they're going to limit reimbursement to the fee schedule. They limited reimbursement to the fee schedule. So what does the statute say they have to do when they do that? The statute says they have to pay 80% of 200% of Medicare. And
That's
then,
a conclusory statement, counsel. Walk us through the actual language and tell us why that is. I mean, you just made a conclusory statement about the issue, the entire issue in the appeal. So walk us through the language. Why does the statute say what you just said?
the statute says what it says because that's what the legislature wrote. So if you look at 5A1, the Supreme Court said it's a different payment methodology than 5A. So
Correct.
we have,
Which, by the way, counsel, is clear on the face of the statute. I think everybody agrees that those are two separate payment methodologies.
so the statute then says the insurer may limit reimbursement to 80% of the following schedule of maximum charges. This court found that is the amount that the insurer is required to pay. Okay, so then we go down.
Yes, that's a different question. Like for our hands-on, our prior opinions, whether we're bound by those still is a separate question. I agree. That's what we seem to hold in those opinions. Is that what so you're basing your argument right now on our prior opinions as opposed to the statutory language?
Your prior opinions are based on the statutory language.
Well, I mean, I think that's what we're talking about. We're sort of asking the question, were we
I
correct?
don't understand the question then, Judge.
Well, I'm not sure we were correct in those prior opinions. I don't know.
And I don't know why you don't think you are correct. When we look at the prior opinions, they're all based on application of 5A1 through 5. And we're looking at them saying, all right, they said in this particular instance, if we're talking about disability benefits, 60%. If we're talking about death benefits, no percent, 100%. If we're talking about the fee schedule, we're talking about 80% of the schedule of maximum charges. But the exception to all that is if a charge is less than 80% of 200% of Medicare, then the insurer doesn't have to pay up. That would be the alternative, paying 80% of 200% of Medicare. You can pay the amount of the charge submitted, which would be the amount of the charge at 100%. There's no limiting language there. And the only way, and earlier when I was talking about the floating 80%, that was coming straight from Progressive's brief, where they were saying that the 80% applies to everything, regardless of what else is written.
Well, counsel, we're not bound by what appellees argue, right? Right? I mean, we're not bound by that.
Absolutely. But the point being is that the only argument that Progressive has to say that it applies to that last sentence in 5A5 is that it's floating. And I'm just simply saying there's nothing in the statute that is that indicates that payment, what they meant to say, or that they did say, was that if the charge is less than the amount allowed above, then the insurer can pay 80% of the submitted charge. It says,
Well, at the end of the day, your position is that the language that this court relied on and hands-on and its progeny in the statute that says the insurer may pay the amount of the charge submitted. Your position is that the rest of the other parts of the statute don't give us any clues as to what that means, and that really we have to, I mean, there's really no other evidence of what amount of the charge submitted means in the rest of the statute. We have to, basically, that's all we have is that one phrase.
Well, again, 5A1 is a limit of reimbursement that is, we're not looking at 1A, we're looking at 5A1.
Mhm.
And so in that instance, we got to look at that all together. And there's nothing that says that 80% applies to that last sentence of 5A5.
So where in either the statute or the Supreme Court opinion does it say because you're looking at 5A1, you can't look at subsection 1A? That you are bound by one or the other?
I'm interested in this answer as well.
This is it's easy. You just look at what's required in 5A 2 through 5, because if you look at what's required in 5A 2 through 5, and I'm just pulling those back up here. For instance, if you're going to rely on the fee schedule, if you're an insurance company, you're going to rely on the fee schedule. You cannot use utilization limitations. Okay. That are applicable under Medicare or workers' compensation. If you're going to rely on the fee schedule, you cannot rely on reimbursement restrictions with respect to licenses. If the insurance company relies on the fee schedule, the provider cannot balance bill the difference between what the insurance company reduced pursuant to the fee schedule and what was ultimately paid. There are hard,
but it can't do those things to contest reasonableness. When we're talking about 1A, we're presuming reasonableness. They're conceding reasonableness. They're not arguing with you about the reasonableness of your bill. They're saying, you gave us a bill, it's reasonable, we're going to pay you 80% of it.
I don't understand the question, because it takes us out of what they chose to do, which is pay pursuant to the fee schedule.
Well, counsel, I mean,
No. I think what they chose to do was limit pursuant to the fee schedule. I'm sorry, I didn't mean to cut you off, Judge.
No. I mean, look, you and I are asking the same question.
I guess I'm failing to understand how I'm not answering it, other than the point being is that if you're going to say that your policy lets you limit pursuant to the policy says we're going to limit pursuant to the fee schedule, you actually do limit pursuant to the fee schedule.
Well, I guess, counsel, I guess that's the problem, is that I'm not sure I read limiting. Oh, did we lose? Counsel?
Yeah, sorry. No, I apologize.
I'm not sure I read a policy that says we're going to limit payment to the fee schedule as saying we're going to pay every claim by the fee schedule. That sounds like a seal. That sounds like they're simply disclosing to someone, hey, there's a ceiling on how much we're going to reimburse. So I think maybe that's where the disconnect is here.
Well, the disconnect is corrected when we go to the EOB and it says this is what we actually did. So they said the legislature gave them and said you can limit reimbursement. Use those words, may limit reimbursement. Their policy says we will limit reimbursement, and their EOB says we did limit reimbursement.
Okay, but without, I was just trying to get that preliminary argument. So you agree that without the EOB, your opposing counsel would be correct. The statute would allow them to pay 80% of the reasonable charge. But because your argument is because they then sent the EOB saying, hey, we're using the schedule, you're saying now that changes it. I mean, that might be a fair argument.
Well, in part, but their policy couldn't be any clearer that we will limit reimbursement to and pay no more than 80% of the following schedule of maximum charges. And they go,
I agree. That seems clear to me. It says limit and pay no more.
then that
That's
takes
pretty
us
clear.
right into 5A2 through 5. They have to follow those rules. There's
To me,
there's
that's,
nothing-
counsel, to me, that's clearly a ceiling.
well, okay, it's a ceiling, but what it's saying is you, in 5A5, you don't have to pay up to the ceiling if the charge is less than 200% of 80% of 200% of Medicare. You can pay less. We're not making you pay up to the ceiling.
Right.
We're going
No,
to
I
let you pay less.
Counsel, look, that's exactly what we said in hands-on. It's a fair argument. I think we're just trying to say, look, we're just trying to find out, hey, your position is that there is no indication of meaning for what the charge, amount of the charge submitted means outside of 5A.
Right. It means what it says, which there's no.
No, hold on. There's no indication of meaning outside of 5A. So in other words, if we look outside of 5A, there's nothing in the statutory text outside of 5A that will tell us what that phrase means. That's your position, and that's a fair position, I suppose, because that's what we said in hands-on.
Well, the position is buttressed by the fact that every other spot in the statute where the legislature wanted to limit reimbursement, it said what it would limit what percentage it would limit reimbursement to. And in this particular instance, in the last sentence of 5A5, there's no limiting language. There's no percentage listed there, and so we can't just create that where there's not one in existence.
Are we bound by hands-on and it's
Well,
the following cases?
You're the court that issued the opinion. I wouldn't presume to say that you're bound by prior decisions of the same court, but I think if you look at
Well,
what you
we
said,
would be unless MRI, I guess, unless our MRI associates implicitly overrules them, right? I mean, we would be bound probably.
well, yeah, and you did have MRI associates. I don't agree at all with Mr. Hazuri's, his mention of affinity as being this kind of like, oh yeah, we just kind of ruled on this issue on the side. No, MRI associates was before this court via supplemental authority, and I would never argue to this court that you didn't consider something that was filed as supplemental authority. You looked at it, you didn't agree with that it overruled your prior decisions, and you affirmed. So I think the same result should be here. So thank you for your time.
Thank you, counsel. All right, we'll give the clock a second to reset. Okay, looks like we have 4 minutes and 19 seconds in rebuttal. Counsel for appellant, you are recognized.
Thank you, Your Honor. I want to say something quickly, then I'm going to get back to the statutory interpretation because I think that seems to be the key issue. The EOBs, the explanation of benefits, are found at record sites 130 through 133. They do not state that that Progressive paid pursuant to the fee schedule, as was stated by opposing counsel.
Counsel, we can certainly double check those, but
That's why I'm giving them to you.
Yeah, we're focused on the
however you see
statute
fit.
right now.
That's where they, I just looked at them. That's where they are. I don't see it. I'm moving quickly. I could have missed it, but I don't think you'll find it in there. But I want to get to the key issue here. Back to, I want to put together the statutory interpretation. I'm going to be a little bit repetitive just to provide context. 1A, 80% of all reasonable expenses for medically necessary services. All, 80% of all means all, heart of the PIP statute, the overriding fundamental coverage mandate. Language in 5A, and keep in mind, the fact-dependent methodology existed long before the schedule of maximum charges. They call it the default methodology. In their brief on page 18, the default method, which is the long-standing fact-specific analysis of whether a healthcare provider's charges are reasonable. That's always been there, and it's always been 80% of whatever is reasonable under the fact-dependent methodology. The language I was talking about in 5A, the opening thing talks about a provider, quote, may charge the insurer and injured party only a reasonable amount pursuant to this section for the services and supplies rendered, and the insurer providing such coverage may pay for such charges directly to such person or institution. So they talk about paying a charge. It doesn't say 80% of the charge because it's understood from 1A that it is 80% of the charge. That's the coverage mandate. So this is what I'm talking about when you look at the statute as a whole. Then you go to 5A5 and we have the sentence that we're talking about. I readily acknowledge it could have been worded perhaps more clearly, okay? But when you look at its location in the PIP statute, a sentence in a subparagraph, halfway through, long after the overriding coverage mandate, and it says the insurer may pay the amount of the charge submitted, we would submit to you that what they're saying is the insurer can satisfy its coverage mandate by paying 80% of the charge submitted. You can accept the charge and pay 80%, just as has been the case since the beginning of the time, 1971, when the No Fault Act came in place. You can accept the provider's charge as reasonable, and that's great. The provider's happy because they're getting 80% of what they billed, and you can pay it. Now ask yourself, why would the legislature's authorization to put in a schedule of maximum charges as a cap, as you correctly pointed out, Judge Eisnagel, a limitation, not something that says you're going to pay all charges at that. Both MRI Associates and the policy say it's a limitation. We're not paying all charges. Now ask yourself, if the legislature was putting that into place, the schedule of maximum charges as a cap, why would it all of a sudden say, oh, but if the provider bill, if the provider bill is less than the maximum amount that could ever be payable, you have to pay 100%. What would be the purpose of that? Where would that come from? That makes absolutely no sense. And that wasn't the legislature's intention here. The legislature's intention with this last sentence of 5A5 was to simply say, if it's under the fee scheduled amount, the maximum, the cap amount, accept the charge and pay it at 80% under your coverage mandate. We submit to you that's the correct interpretation of the last sentence of 5. I do want to say that the second DCA on Back on Track adopted an alternative interpretation, which is simply that the sentence says the insurer may pay the amount of the charge submitted. May is permissive, just like it was interpreted to be permissive in virtual orthopedics specialists and MRI Associates. And so it gives the insurer the option, but not the requirement to pay it 100%. That's another conclusion you can reach that is consistent with the entire PIP statute and doesn't say, well, just because you elected it as a cap or a maximum limitation, you have to pay all charges like that.
All right,
which is
thank you,
not
counsel.
the case.
Your time
Thank
has
you.
expired. I will, look, great argument on both sides. This is clearly a very difficult issue. It's not an easy one at all. And so nice job on both sides. And with that, this court is in recess. Thank you.
Thank you.